a fast-moving effort to bring into play one small clause in the Constitution threatens to completely upend the race for the Republican nomination and quite possibly knock out the frontrunner, the twice-impeached, multi-indicted insurrectionist former President Donald Trump. 1 month ago, the idea that Section 3 of the 14th Amendment could disqualify Trump from holding public office again was mostly conjecture, something mainly debated among the inner circles of legal scholars. But a paper published this summer by William Baude and Michael Stokes, a pair of prominent conservative law professors and members of the Federalist Society, brought a new spark to the conversation. That paper quickly prompted two of the most revered legal minds of our time, the Harvard University professor emeritus Lawrence Tribe and the retired former federal judge J. Michael Luttig, to write a widely read piece for The Atlantic bluntly titled, "The Constitution Prohibits Trump from Ever Being President Again." Professor Tribe and Judge Luttig appeared on this show at the time of that article's publication to discuss how Section 3 of the 14th Amendment is so-called self-executing, and that due to his role in the January 6th insurrection, Trump is ineligible to hold public office. Their endorsement of the idea gave the movement a jolt of momentum. And now, less than a month after their piece was published, a lawsuit has been filed in the state of Colorado by the government watchdog group Crew on behalf of 6 Republican and unaffiliated voters challenging Trump's eligibility for the presidency. This might be the strongest case to emerge so far that could eventually force the courts to determine whether or not the former president is allowed to appear on the ballot for the upcoming presidential elections and primaries. And perhaps more importantly, it will force the courts to clarify the meaning of Section 3 of the 14th Amendment, also known as the disqualification clause, which states, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof," end quote. Now, that's the literal reading of it, but the exact meaning of the disqualification clause and how it can be applied in real life has largely been untested for the past 150 years, simply because there hasn't been an insurrection or anything resembling one in the United States during that period. That is, until Donald Trump came along and brought American democracy to the brink of collapse in his desperate attempt to stay in power. As recently as this past May, Trump has vowed to pardon a large portion of convicted January 6th rioters if he's elected president again. And in June, he even spoke at a fundraiser for January 6th defendants, which was held at his own golf club in Bedminster, New Jersey, and promised to make a contribution to their legal fund. Now, reasonable minds have reasonably concluded that Trump himself incited the January 6th insurrection, but there isn't a lot of legal precedent that can tell us definitively if the courts, who will undoubtedly get this case, will interpret it the same way. So, let's go right to the brains of the operation. Joining me now is one of the legal scholars who helped bring this question to the forefront this election season. Lawrence Tribe is a professor of constitutional law emeritus at Harvard University. He's the author of several important books, including the influential legal text, American Constitutional Law, which has been cited more often than any other legal text in modern history. Professor Tribe, it is good to see you again. Thank you for being with us. This is a continuing conversation between us because there is a great deal of complexity and a lot of movement in it. So I want to just ask you, first of all, in a post on what used to be known as Twitter, you wrote that the Colorado lawsuit is, quote, "the strongest of the suits filed to compel secretaries of state to apply the 14th Amendment's disqualification clause to Trump. The 6 plaintiffs clearly have standing under Colorado law, and ironclad legal and factual research backs up their complaint," end quote. Tell me why you believe this case is strong and stands apart from others.
Well, thank you for inviting me back, Ali. It's an honor to be on your show. I think it's the strongest because the elaborate complaint explains that they don't expect a mere statement of opinion about Trump's disqualification to remove him. What they are asking the court to do, the state court, where these plaintiffs clearly do have standing under Colorado law, is to conduct a factual and legal hearing involving all of the evidence that many of us have seen and that some have not.
I need to just interrupt you. I'm very sorry about this, Professor Tribe. The president has just started speaking. If I could just ask you to hold for a second. But I want to go back to Professor Laurence Tribe. Professor, I'm sorry for that interruption. Very, very little would cause me to interrupt a discussion with you, but listening to the president talking about global affairs is probably one of those things. So let's just, for my viewers' benefit, go back to that first question. This lawsuit has been filed in Colorado. The president and his team have tried to have it removed to federal court. Crew then went back, I think 2 nights ago, and said, no, this needs to stay in Colorado court. It seems like the president and his team have agreed that that's where it has to be. Why is this challenge in Colorado the important one?
The reason, and I can't imagine interrupting the president, but it is what it is. And I think this is terribly important because who the next president will be certainly depends in part on who's qualified to run. And the qualifications include not having taken an oath to uphold the Constitution and then committed insurrection against the Constitution and the principles for which it stands. Colorado is a special place in that respect because, unlike many other states, Colorado has a specific statute which allows registered voters to take the Secretary of State to court and demand that the Secretary of State exclude anyone who doesn't meet all of the qualifications, even at the primary stage. And of course, one of those qualifications is that you not have committed what amounts to treason against the Constitution. The Secretary is, in this lawsuit, going to be required to conduct a hearing. She's not just supposed to shoot from the hip or offer an opinion from the top of her head. She's supposed to hold a hearing based on all of the evidence that's been gathered ever since January 6th on how the president tried to overturn a fair and free election by illegal means, including not just fomenting a violent insurrection, but also giving aid and comfort to that insurrection through a number of methods, including fake electoral slates. That hearing is now going to take place in Georgia unless the state trial court refuses to enforce the state statute. That's not likely. Whatever the conclusion of that hearing, it's going to go all the way up to the Supreme Court. And Judge Ludig and I both, even though we disagree on a lot of things ideologically, believe that taking seriously every part of the Constitution is absolutely essential to the continuation of the American Republic.
Well, thanks to you, we're all reading our copies of the Constitution, and I want to read to you from the beginning of Section 3 of the 14th Amendment, in which it says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, and then it goes on. So it talks about hold any office. I spoke with the Colorado Secretary of State, Jena Griswold, on this show yesterday, and one nuance that we were discussing is whether Section 3 bars someone from running for office or being seated in office. Have you examined that?
It seems to me very clear that Section 3 basically applies to holding the office. But the Colorado law quite sensibly says if you can't hold the office, then you shouldn't be listed on the ballot. And that is what the state statute says, and that's what this lawsuit asks the secretary to enforce. But ultimately, the meaning of Section 3 has to be explicated in this ongoing litigation. If the U.S. Supreme Court ends up deciding, no, it only prevents you from being president, not running for president, that's going to create a terribly chaotic situation. But the U.S. Supreme Court has not always avoided chaos. So we'll just have to see how sweeping the disqualification clause is.
The corollary is that if I have to be born in the United States and 35 years old and I apply to be on the ballot, the Secretary of State's office should probably ask me to prove that I'm over the age of 35 and born in the United States. And if I'm not likely to make it onto the ballot.
That's exactly right. Or if you are ineligible for any other reason, like suppose some people wanted to put Barack Obama on the ballot for the Democratic primary, or maybe Bill Clinton, or they wanted to put George W. Bush on the ballot to run against Trump. The reason they couldn't do that is that the secretary, be pretty quick hearing, would conclude that they're not eligible because they have already had 2 bites at the apple, and under the Constitution, third is not allowed. This is, of course, more controversial because it's not as mechanical. That's why we've got a 140-page or whatever it is, 128-page complaint, and that's why it would have to be an elaborate hearing. You couldn't just say, oh, he's obviously an insurrectionist, end of case. Clearly, we're going to have to explore in this trial the meaning of insurrection, what it means to be engaged in it, to give it aid and comfort. I think it's pretty obvious to most people that if Trump doesn't qualify, nobody would, and the disqualification for insurrectionists would become a dead letter. And that's not what any part of the Constitution is supposed to be. This was a major protective provision put in there because they realized that those who take an oath to uphold the Constitution and then turncoat against it might not end up being prosecuted for anything. This isn't a punishment.
Right.
At the time, people weren't being prosecuted by Andrew Johnson's Justice Department. This is a disqualification, and it's important for the survival of the Republic that someone who has shown him or herself to be an insurrectionist against the Constitution not get another chance to try.
Yeah, that's a very important distinction that I think we have to keep on making. This is not a crime, nor is it a criminal punishment. It is a disqualification. I want to ask you, because you have a whole lot of people who otherwise are not consulting their constitutions doing so as a result of your piece with Michael Luttig. Amendment 14 has 5 sections to it, and Section 5 is a clause that is repeated many times throughout the Constitution. It is an ending sentence, and it says, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Tell me how you interpret that in this context. Is there work for Congress to do here or not? Because when I spoke with you and Judge Luttig, your general view is you don't need Congress involved in this.
That's right. Congress could make things easier by setting up a special procedure under Section 5 for enforcing Section 3, just as it has put in place civil rights laws for enforcing the liberty and equal protection clauses of Section 1. But like the liberty and equal protection clauses, this one has meaning even without enforcement legislation. For example, if a state's highest court renders a judgment that deprives someone of liberty without due process of law or equal protection of the laws, you don't need Section 5. You go straight to the U.S. Supreme Court and say that that decision must be reversed because it's inconsistent with the language of Section 1. Likewise, if some court were to say, for example, we don't think you need to have a disqualification hearing about Donald Trump because this language died years ago. It was only about the Civil War. And there are a few people who have made that argument. That argument, I think, would not survive in the Supreme Court. There are a number of others that might. But whether or not Congress, which is not the easiest place to get anything done, enacts enforcement legislation under Section 5, this section, Section 3 of the 14th Amendment, has to be enforced in every context where it is relevant to the decision.
Professor, I have a number of viewers who are saying on Twitter that this last few weeks has been like being in a law class with you and Judge Luttig, which would be quite a privilege if the two of you were to teach a law class together. We appreciate this. This is definitely more than sometimes somebody needs on a weekend morning, but this is crucially important. So we really, really appreciate the detail that you're getting into with your experience and your analysis.